the option is that they order all those records, look at it, and they're like, oh, you absolutely are continuing to be disabled, is my understanding. They could just find based off the paperwork you're continuing to be disabled. Or they could say, we don't think you're disabled anymore. We're going to cut you off benefits.
Well, that's correct. You're right. You're right.
And then what is your options if they do that? Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. Good morning, Isabella Baez. How are you?
Good morning, Peter. I'm good. How are you?
Doing great. Living the dream, as they say. So first of all, let me introduce you. For those who don't know who you are, and I'll put that bio interview that we did, that biography interview that we did, into the comment section for those who might want to learn a little bit more about you. But your name is Isabella Baez. You go by Izzy, and you're an attorney that works for our firm, and primarily focusing on federal court appeals up into the United States District Court. But we also ask you to cover hearings as well at the administrative level, and sometimes even hearings at the local Social Security office, or kind of even before it goes to before an administrative law judge. I shouldn't use the word formal because it's informal technically. It may feel more formal when you go to an administrative law judge. So that's you. You've been working for our firm for about 3 years, went to University of North Carolina Law School, I think now a top 20 law school in America. And so we feel very lucky to have you. And just on a personal note, after knowing you for about 3 years, you just have such caring and passion for the community in which we serve. And so, and that shines through in your work and how you approach clients. And so all of that is so appreciated. So welcome to the Evans Disability Podcast. So today I want to talk about continuing disability reviews. I think it's, a lot of times we get calls in into the firm from potential clients who really are looking for help for their continuing disability review, or CDR for short. And so I know you've helped represent people through the CDR process. And so today I want to sort of talk about that with you. And so maybe we can just start in the beginning of kind of what is a CDR, what triggers a CDR, and then sort of what happens if they're saying, hey, we're going to cut you off benefits, and then kind of go from there.
Sure. So, well, first, thanks for the kind words, Peter. I appreciate that. But a continuing disability review is basically when SSA periodically reviews the claims of everybody who's already receiving disability benefits, just to confirm that they still fit that definition of disability. That is, that they're still unable to work enough to support themselves. And that's what a CDR is. So if you receive a letter basically from SSA saying that they're going to be auditing your case, it's usually pretty routine. It happens usually every 3 years is what the regulations state, is that what SSA requires. But they can happen every 3, 5, or 7 years. And usually what the first thing you'll see is you'll get that notice, and you'll also get a form to fill out. As for what triggers a CDR, there can be a few things. So the first thing that I personally have seen is when you get your initial favorable decision, the administrative law judge or whoever did actually give you a favorable decision, whether that had been a lower level agent, like at the DDS level, they can actually recommend a continuing disability review at any point. Sometimes I've even seen at the 12-month mark for a CDR, but usually it is within that 3-year range. So that is one thing that can trigger a CDR. There's also other things such as if you've been receiving SSDI for less than 24 months and then you start working again. That's a pretty big one. If you actually tell Social Security that your medical conditions have improved, that will probably trigger a CDR. Another one is if someone kind of accuses you of fraud or misrepresenting kind of the facts of your disability, that could trigger a CDR. If you're not following your prescribed treatments, and then also if a new treatment happens to become available to you, and you start basically becoming better, that all those things could probably trigger a CDR.
So let's talk about they trigger a CDR. What's the first thing that will happen? And you said Social Security will mail them, the claimant, a form and a letter saying we're going to review your case. And my understanding is the form, or one of the forms, is that they want authorization for release of information. And a lot of people will say, do I need to sign this? And the answer is yes. If you want to have a continuing Social Security disability benefits, you absolutely need to sign that. And what you're authorizing them to do is to go out and order medical records or work records or records that may affect your disability claim. Am I correct in that? It's been a while since I've done a CDR, so I'm going to lean on your knowledge here a little bit more.
Yeah, it is really important for you to sign off to release of information. It's kind of the exact same as the regular disability process, where you do need to release that information, or else, SSA can't get anywhere if they do need to order records or anything like that. So you're correct.
And then the people handling the continuing disability review is the local office. A continuing disability review doesn't just start at a hearing level in front of an administrative law judge. So it's not the Office of Hearing Operations, is my understanding, that it is the local Social Security office who's doing it.
That's correct. It's usually DDS. So the offices that kind of handle the initial and reconsideration stages are kind of enveloped in where CDRs take place.
Right. So then they go out, and then talk about the form. Do you know what form it is?
Yeah, it's a SSA 455. It's called a disability update report. And it usually comes with that notice that SSA will send you in the mail stating that they're going to be doing an audit or that CDR of your case.
And generally speaking, do you know what kind of questions and I'm curious because I haven't looked at that form in a while. Do you off chance know what kind of questions are asking in that form, or?
Yeah. So it starts off by asking, about your work. It asks if you've done any sort of self-employment or any sort of wage type work. It also asks, have you done any type of schooling, or any like vocational training? So it'll go through those things, and it's pretty easy. You just say yes or no. And then it gets into kind of the disability part of it where, select which of the following describe your health as compared to the last 2 years. Is it better, the same, or worse? And you can check off boxes like that. And so there's kind of, questions related to that, related to whether you've talked to your doctor and whether they believe that you're still disabled. So those are the types of questions that kind of come up on the 455.
Right. Well, thank you. again, it's been a while since I've seen that form. So, so then you turn in the paperwork. What happens after that? What are the pathways that can happen after you turn in all the paperwork?
So then you would basically be waiting for a notice of kind of your hearing. And again,
before we go to the notice hearing, the option is that they order all those records, look at it, and they're like, oh, you absolutely are continuing to be disabled, is my understanding. They could just find based off the paperwork you're continuing to be disabled. Or they could say, we don't think you're disabled anymore. We're going to cut you off benefits.
Well, that's correct. You're right.
Right. And then what is your options if they do that?
Right. So if you're not immediately approved based on the evidence that's provided at the start, then you can appeal, in which you can be afforded what SSA calls an informal hearing with one of those DDS agents, where you can kind of put on your case like it was an administrative law judge. You kind of treat it the same way as your hearing that you might have done in your initial case, where they'll just basically ask you, in the past 3, 5, or 7 years, depending on how long you've had your disability benefits, how has your disabilities progressed?
Right. That informal hearing, and it can be confusing because they also called the hearing in front of a Social Security judge an informal hearing, and this is not that. This is down at your local Social Security office, and I think you can do it by phone as well, or you can go in person. I don't during the pandemic, obviously you couldn't go in person, but or you can go in person now. And they have a person that kind of travels between the local offices, and or several people, I'm sure, that do these really, really informal hearings. I've done a couple of them personally. I know you've done a few of them personally. I'm curious, maybe you can describe your experience, and then I'll talk about my experience.
Sure. So kind of my experience with it was that the DDS agent would call us and call the attorney, call the client, and then kind of say, a little introduction about this is how this is going to work. Again, this is an informal proceeding. I'm not recording this session, which I think is kind of an important thing to note, that basically the DDS agent is just taking their own notes on basically what the client is saying. And then they basically go into kind of what the form lays out, and they'll start off with questions about, have you done any work? And they're kind of going through like, oh, was this person telling the truth on their form? And kind of just like parse out some more details. So have you basically kept going to treatment? What types of treatments have you been getting since you were awarded your last benefits, and things like that. So it was really similar for me in my experience to an actual, a real hearing with an administrative law judge.
Yeah. So my experience was, the one that stands out to me the most, because it's one of those hearings I'll never forget, is that we went down to the local Social Security office, and we did it in person. We walked in, there was a little back room, and the hearings administrator, and it's not a judge. My understanding is they have they don't have a law degree. They are someone who's been sort of promoted to this position or hired to do this, but they're not a judge, and they don't have a law degree. You go into this back room, and at the time it was me, the client's witness, and this person. And they literally had what I would guess a 10-page form, maybe give or take, a couple pages. And they are reading off the questions from the form and handwriting in the answers, a summary of the answers. And the reason I won't forget it is because I wanted it I personally wanted it to be recorded. And at the time, and this was years ago, at the time, the decision maker, the administrator who was handling the CDR, was really, I think, offended that I even asked that it could be recorded. And part of the issue for me is why I wanted it recorded was because I think anyone who is transcribing a summary of what's being said can be difficult if it's not accurate, or recordings can be more accurate. And so her and I sort of talked about that and got into it a little bit, just about the importance of a recording and why I wanted it recording. And I told her it's no reflection on her and her ability to take notes. I just think a recording was more accurate. So ultimately, I think we ended up recording it on my phone, having the recording, and then it ended up not mattering, and for lack of a better word, too much, because she had granted continuing disability benefits. So like a hearing, for people who've gone to a Social Security hearing in front of an administrative law judge, you'll probably find this to be less formal. They're not wearing a robe. You're in a small little conference room in your local downtown Social Security office, or wherever your local Social Security office is. You're sitting at a conference table, or the judge is not at a bench, not wearing a black robe. It's stressful because at the same time, you might lose the benefits you have. When you walk in, and this is, I think, why the recording was important to me, is that they actually put the client or the claimant under oath. And they're asking the claimant to raise their right hand, tell the truth, the whole truth, and nothing but the truth. And because of that, I wanted it recorded. But they do that, and then again, they just go through this checklist of questions on a form and handwrite out the summary of the answers. And then once that's done, we were afforded the ability to call a witness. And in that witness testified as well under oath. And then there was sort of a summation that I gave at the CDR hearing, and then it was over. Whole thing lasted probably an hour, 45 minutes. It could have been shorter had we not had this big discussion about recording. But so yeah, the whole thing lasted about an hour, in and out. You have to remember, for audiences who've never been in front of a Social Security judge, it is like a hearing where you are sworn to go under oath, but it's not recorded, and so that's a little bit unique. Many clients, and I'm gonna throw this question at you. Well, before I do that, the one thing you have to remember, it is in the Social Security Administration's office, at least where I went. So if you're going to go in person, just remember to show up a little bit early. You're going to have to bring photo ID. You're going to have to go through security, metal detector tests and all of that at your local Social Security office, even though it's not, quote unquote, a courthouse. And you're going to have to kind of go through that process, and then you check in and then sit in the lobby and wait for the administrator, or I don't know their specific title, but the hearings person to call you, and you go back into the little conference room. I think one of the questions that I want to ask you to hear your perspective on, and I will give my perspective as well if it's a little bit different, is that we get a lot of calls from people asking if we can represent them at this particular hearing. And many attorneys, many attorneys will not do it. And I'd like to hear your perspective on why, because I'm not sure if lawyers explain it, or if to the folks on the phone that are calling and asking for help. But we have a little bit of a different policy than other folks, other lawyers. But I'd like to hear your reasons on, or the things you think of why other lawyers may not represent folks who have a continuing disability review hearing?
Yeah, so I